So we have dealt with that affidavit before, and maybe in a slightly more cursory fashion. So it's not new to the commissioners, this affidavit.
Okay.
They've seen it before. Thanks.
So if I can take the commissioners to page 18 of my statement, in particular paragraph 1.7.1. So in order to go forward, we have to go back a little bit. And what I'm saying here, if we go back to the media conference of the 6th of July, 2025, there were two central themes of General Mkhwanazi's press conference. The one was organized crime's infiltration of the criminal justice system, and the other was political interference in the police by the Minister of Police. Those were the two central themes, and I think that's common cause. I've dealt with, in some detail, the examples of infiltration of the underworld into the police and the effect that has had on the police. And I've said it wasn't new. And I'm making the point here by saying, nor was political interference in the SAPS new. The irony of the latter fact is that during his period as acting National Commissioner in 2012, General Mkhwanazi himself turned a blind eye to unlawful political interference relating to the then Divisional Commissioner of Crime Intelligence, Lieutenant General Richard Mkhwanazi. In fact, General Mkhwanazi not only turned a blind eye, but he also acquiesced to patently unlawful instructions, then later helped to cover it up. And that may be considered a very serious allegation. But the evidence I will present will actually bear out this allegation, Commissioners. And first of all, we start with this paragraph 1.7.2, which rambles on. And what it is, it's an analysis of Annexure T. And Annexure T is the self-same affidavit presented by General Mkhwanazi to the State Capture Commission, and it's dated 29th of September 2020. Now, in that affidavit, he makes certain averments under oath. And what I've tried to do here is to capture those averments. In other words, to coin a phrase, explain what it is he was saying under oath. And I want, rather than read out every single one of those sub-paragraphs, I want to jump forward to page 20 of my affidavit and go to sub-paragraph 1.7.2.8. And the last four lines of that sub-paragraph states, quote, "Finally, under pressure from the Minister of Police at a meeting to which he called the Inspector General and General Mkhwanazi, the Inspector General," this would be the Inspector General of Intelligence, Commissioners, "the Inspector General reinstated the opinion and recommendation. I cannot think of a more blatant demonstration of unlawful executive overreach." It's me saying that. And then I go on to 1.7.2.9. At the meeting with Minister Mtetwa, and this is based on his affidavit, at the meeting with Minister Mtetwa and the Inspector General of Intelligence, the Minister instructed General Mkhwanazi to uplift the suspension of General Mkhwanazi. General Mkhwanazi later claims to have informed Minister Mtetwa at the meeting that his instruction was illegal. Nevertheless, he acquiesced. General Mkhwanazi has always been deliberately vague about the dates and times of these meetings. Given the importance of same, there can be no legitimate reason for this vagueness. And then we continue on page 21. 17210. Following the meeting with the Minister of Police and the unlawful reinstatement of the Inspector General's opinion, bearing in mind, according to his version of events, the Inspector General of Intelligence was like a straw in the wind, flip-flopping, 1 minute saying this and the next minute saying that, and then going back to the original. It says here, General Mkhwanazi uplifted the suspension of General Mkhwanazi on the 27th of March 2012, and he returned to work, where he was also handed the additional responsibility of protecting the President and ministers. So this whole division in the police, called the Security Division of the Police, which is the VIP protection units, was now suddenly handed over to the head, the divisional head of crime intelligence, which is Richard Mkhwanazi. And then, on the 15th of May 2012, thank you, Commissioner, for pointing out the 1 and 2 being the wrong way round, after the Freedom Under Law application was launched, new disciplinary proceedings were instituted against General Mkhwanazi, and on the 25th of May 2012, General Mkhwanazi recanted his earlier decision and suspended General Mkhwanazi again. Public pressure was building. At the start of June, General Mkhwanazi met with President Zuma and appears to have been pressurized to withdraw the new disciplinary proceedings against General Mkhwanazi and his suspension. This is based on his version of events. At the meeting, it was agreed that General Mkhwanazi would not continue as acting National Commissioner beyond the few remaining weeks that were required to appoint a new National Commissioner, General Piega, with zero policing experience, who, well, that's just my throwaway, was duly appointed on the 12th of June. So now suddenly, General Mkhwanazi, who's been the acting Commissioner of Police since the prior year in September, is now suddenly no longer the acting Commissioner of Police. And then I go on to page 22 at 1.7.3. I say, on its own terms, the narrative of General Mkhwanazi shows that he readily succumbed to political pressure and implemented the illegal instruction of the minister to uplift the suspension of General Mkhwanazi, whilst all material times knowing that this instruction was illegal. How do we know, Commissioners, that at all material times he knew the instruction was illegal? Because he says so under oath in 2020. But here's the best part. When he enacted this unlawful instruction in 2012, he was invited to Parliament, and on the 19th of April, he was asked at Parliament why he had uplifted the suspension of General Mkhwanazi and put him back to work. And his answer was short and sweet. He said, I acted according to higher authority. And when he was asked what the higher authority was, he declined to say. On the 15th of May, when the Freedom Under Law application was launched, there were two sections to it, a Part A for urgent relief and a Part B, which was a confirmatory of the urgent relief. And the urgent relief that Freedom Under Law requested, and I've got all the pleadings, the urgent relief that Freedom Under Law requested was that the decision of General Mkhwanazi was to be declared unlawful and invalid, and that General Mkhwanazi was to be put back on suspension and removed from doing its police work. Now, that Part A application was launched on the 15th of June. It was an urgent application. General Mkhwanazi supplied the answering affidavit. And in the answering affidavit, he doesn't deny that he was acting on a higher authority. In fact, he keeps quiet about it. He keeps quiet about it for 8 years and only comes out with it in 2020. So from 2012 to 2020, nobody in the country knew that he had acted on the unlawful instruction of the then Minister of Police, Nathi Mthethwa. And that is the point I'm making here. So then I say at 1.7.4 on page 22, when regard is had to the facts of the freedom under law application, General Mkhwanazi's collusion with the illegal interference of the Minister and the President is even more stark. The chronology of the freedom under law matter is the following, and I set out the chronology. And at 1.7.5, I say the following. There are two noticeable aspects of General Mkhwanazi's conduct in relation to the freedom under law litigation that show he assisted to cover up the executive interference in the SAPs, which he knew to be unlawful. 1.7.5.2. First, in the face of the founding affidavit from Freedom Under Law that specifically alleged executive interference in an attempt to pressurize him to withdraw the disciplinary action against General Mdluli and his suspension, General Mkhwanazi did not admit the relevant facts. Instead, he deposed to an affidavit which did not respond to the allegations, but nevertheless opposed, on spurious grounds, the urgent interdict sought to prevent General Mdluli from executing police functions. And this is found at page, the evidence here, Commissioners, I refer to paragraph 49 of the Supreme Court of Appeal judgment, and paragraph 211 of the High Court judgment. Now, if you go to page 437 of the evidence bundle, you will see that I have highlighted a number of paragraphs because it's quite a lengthy judgment. But if you look at page 437 at paragraph 211, this is now the full application. So what you had was a Part A and a Part B. And the Part A was heard by Justice Makhoba J. And it says here, in paragraph 14 of the judgment in the Part A proceedings, Makhoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkhwanazi had not disputed them in his answering affidavit. Now, if you go back to page, or go forward to page 469, which is in the Supreme Court of Appeal, page 469 at paragraph 49. This is now the Supreme Court of Appeal judgment. At paragraph 49, Commissioners, it states, as a factual basis for the challenge of these decisions, Freedom Under Law relied in its founding affidavit on a statement by the then acting Commissioner, Lieutenant General Mkhwanazi, in Parliament that he was instructed by authorities, quote unquote, beyond him to withdraw disciplinary charges and reinstate Mdluli in his office. Freedom Under Law added that in doing so, Mkhwanazi had failed to make an independent decision, which rendered his actions reviewable. Though Mkhwanazi filed an answering affidavit in the interim interdict proceedings in Part A of the Notice of Motion, he did not deal with these allegations. So you had this situation where General Mkhwanazi is facing litigation based on his conduct to unlawfully act on the instructions of the Minister of Police. And what's the relevance of all this, you may ask? Well, his complaint on the 6th of July last year had two legs to it. One was criminal interference or penetration of the police, and the second leg was the executive overreach, the ministerial interference in the management of the police, which is exactly what happened in 2012, and he was a party to it, and not only was he a party to it, he helped cover it up for the better part of 8 years. And only in 2020 does he come out with it.
Yes. Mr. O'Sullivan, I'm just trying to understand the import of your evidence. Are you saying, because of what you describe as his past conduct, are you saying he should not have spoken up in July, he should not have complained about political interference?
Commissioner, what I'm saying is, you can't change history. He did what he did.
Yes.
But what he didn't do when he came to this commission, he didn't take the commission into his confidence and say, by the way, although I'm speaking out about it now, I just want to inform you that 14 years ago, I was engaged in just the same activity.
So is the criticism, I'm trying to understand, as I say, the import. What are we to do with this evidence that you obviously consider to be important to mention? Are you saying because according to you, he was complicit, and at this point, I'm not dealing with whether or not what you're saying he did previously is correct. I'm asking if you're criticizing, as I understand, and please correct me, if you're I understand you to be criticizing him for, on the 6th of July, mentioning or complaining about overreach, political overreach or political interference. I understand you to be criticizing him for that. And I'm trying to understand, are you saying, with that criticism, are you saying he should not have spoken as he did about this aspect of things? This second, you say there are two legs to it.
Well, it's hard to come to a informed answer there, other than to say that was I not to produce this evidence here now, this commission would be completely unaware of the fact that the conduct he's now complaining of was exactly the conduct that he was involved in some years back. And if you're going to be a whistleblower, as he claims to be, you should be a whistleblower with clean hands.
Yeah, exactly my confusion. That's why I'm asking you this question, exactly my confusion. Are you saying he is not a clean whistleblower, according to you, because
Correct.
he previously colluded in similar conduct? Therefore, he should not have spoken up. Is that the heart of what you're saying? And maybe let me suggest to you that I ask the question because it's quite conceivable that someone thinks about it this way. The man had a Damascus moment. He previously colluded, according to you, and then come July 2025, he decides not anymore, and he changes his mind. I'm asking from that perspective, Are you saying he should have kept quiet forever?
Yeah.
Or the other possibilities you're saying, well, because he's got this past conduct, we should disregard his complaint of 2025 and disregard it to the end that he's talking, sorry, I can't think of a better word, he's talking nonsense. There was no political interference in 2025. Is that the point you're making?
So my understanding, Commissioner, and you might have to interrogate me a bit further, but my understanding is quite simply this. If you're going to have a Damascus moment, put that down in writing. Say, look here, by the way, I'm speaking out now because I saw what happened all these years ago. And I was involved, but he didn't do that. He's kept quiet.
Yeah.
And therefore, I think it would have been better, rather than speak out at a media conference, to take action without drawing down the public confidence in the criminal justice system, because it's been shattering what's happened in the criminal justice system.
Okay, I guess I've asked my question and you've answered the way you did. I'll accept that's your best answer. The second issue about it, you've referred us to these judgments. And let's start with at 437, page 437, which is Makhoba J's judgment. Are you saying by not because remember you've highlighted the part and you've read out where the judge says in his answering affidavit,
Sorry, ma'am, if I can just ask the paragraph number?
looking at page 437.
Yeah,
And then-
437.
And then I'm looking, you referred to paragraph 211.
Uh-huh.
And you read there where the judge says, Mkhwanazi had not disputed, maybe let me start at the beginning. It says, in paragraph 14 of his judgment, Mkhoba J, well, I think this is the SCA judgment, in fact, you're referring to. Mkhoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkhwanazi had not disputed them in his answering affidavit. What are you saying there about the conduct of General Mkhwanazi?
What I'm
Yeah.
saying here, Commissioner, is it's not me saying it, it's the High Court. And it's a scathing judgment against, this is what's referred to as the Murphy judgment. And it's a scathing judgment against the police
Yes.
and against, in particular, General Pieka and General Mkhwanazi, against both of them. And this judgment hasn't seen the light of day for probably 10 years or more.
Yes. I'm asking the simple question because, you know, another construction, and I think in our practice that is accepted, is if you do not answer to a specific allegation, you have admitted it. So when I read 211, I would have concluded, until you spoke, I would have concluded, well, it means he didn't dispute it. He didn't dispute that there was political interference. But you seem to be reading that paragraph or to be attaching a meaning to it, that he basically was part of the cover-up, unless by not responding or not denying the allegation of ministerial interference, he therefore covered up, unless I misunderstand you, Mr. O'Sullivan?
Commissioner, you have to look at all the bits that I've highlighted and take them together. But if I go to page 438,
Yes.
Paragraph 215, 216, and 217, and 218.
Yes.
This is scathing. It says, Mkhwanazi dropped the disciplinary charges on orders from above is furthermore borne out by the Rule 53 record filed on his behalf. The record he supplied comprises nothing more than 2 letters addressed to Ndluli, one notifying him of the withdrawal of the disciplinary charges against him and the other advising him of his reinstatement to work. It doesn't say to work. There is no charge sheet or correspondence dealing with blah, 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 and it goes on. And then 216, it says, the inescapable finding is that the decision of the acting commissioner to withdraw the disciplinary charges and to reinstate Ndluli as head of crime intelligence were taken in an attitude of subservience pursuant to an unlawful dictation from a person unknown.
Yes.
Who was beyond the acting commissioner. By the way, at this stage, nobody would admit who it was that gave him the instruction. That only came 8 years later.
Yes.
He says, an abdication of power violates the principle that the responsibility for discretionary power rests with the authorized body and no one else. And
Yes.
it goes on to say at 218, to ensure the proper functioning of the SAPS, the Commissioner, in discharging his obligations under Section 11 of the SAPS Act, must protect and give effect to SLAP's discipline regulations. It's a scathing judgment. And the failure, it's not the judgment that's more important, Commissioners. What's more important to the people of this country is that this has been kept hidden. It's been kept under wraps. It should have been part of the evidence. He said, by the way, the reason I did what I did on the 6th of July is because 14 years ago, I was involved in exactly the same state of affairs, and I went along with it and covered it up for 8 years.
I guess, Mr. O'Sullivan, my question is, what difference does it make? Remember, we consider our terms of reference. And I don't know that we can take it any further, but really my question is, even if you are correct in your position that when he testified here, he should have confessed his previous sin of covering up, as you say.
Yes.
I'm still left with the question, okay, what difference does it make to, he has spoken up. We are investigating exactly that as a commission, whether indeed there's been political interference. Does it really make a difference that, and if so, what difference does it make to how we deal with that allegation of his, that when he sat there and testified, he didn't testify to his previous crime of colluding in the similar decision making that he's now complaining about?
Well, except, Commissioner, it's my evidence that not only was he previously involved in that conduct, but for 8 years he covered it up. For 8 whole years. And it only came out when he made his statement at the Zondo Commission. And when he made his statement at the Zondo Commission, he did not go into the nitty-gritty of what actually took place. He gave a version of events, and I obviously have no first-hand knowledge as to whether or not the then Minister of Police in 2024 or 2025 did engage in executive overreach. I have no knowledge of that. It's not something I've been involved in. But if a person is going to become a whistleblower, surely that whistleblower is going to say, by the way, the reason I'm whistleblowing is because I was involved in this conduct 14 years ago and I saw the effect of it.
Thank you.
Thank you.
Thank you, Commissioner Baloyi. If I understand your summaries of both General Mkhwanazi's affidavit before the Zondo Commission and the Freedom Under Law application, that application was brought in 2 parts: the interim relief in Part A,
Yep.
and the main relief, the review in
Yep.
Part B. General Mkhwanazi deposed to the affidavit in Part A, and I think you make the point in your statement that by the time Part B came around, General Pierre was deposing to that
Correct.
affidavit. So when you charge General Mkhwanazi of failure to disclose, that he would be required to do in Part B, when by then he had already been transferred or to another department and General Pierre had taken his position. Do I understand you correctly?
Then I would point the commissioners at page 25, paragraph 1.7.9
Yes.
and 1.7.10, which I
Yes.
would like to read out.
Okay.
And this is my testimony. Accordingly, even after he was fully aware of the contents of General Pierre's affidavits in the Freedom Under Law proceedings, General Mkhwanazi continued to cover up the illegal instruction he'd been given by Minister Ntetwa and the political interference of both Minister Ntetwa and President Zuma in decisions that he ought to have been able to take, free of any political interference. He could have, at that time, and indeed should have, approached the court with the truth. He failed to do so. He only finally came partly clean when he was interviewed by the investigators at the State Capture Commission, led by Justice Zondo. Even then, his version was a cover-up of the truth, and he fobbed them off by blaming others. Given General Mkhwanazi's own collusion in an illegal process of political interference designed to keep General Mkhwanazi in charge of the Division of Crime Intelligence and its regularly stolen secret funds, it is difficult to take seriously his complaints of political interference that he made in his infamous speech on the 6th of July 2025. In fact, General Mkhwanazi's own unlawful conduct in 2011/12 make the current complaint he has made pale into insignificance while still sharing commonalities. For example, in 2011-12, General Mkhwanazi's conduct was intended to unlawfully protect Crime Intelligence Divisional Head, much the same as his conduct in 2025 is intended to protect the Crime Intelligence Divisional Head and those under him.
If I just take a step back to your paragraph 1.7.9, just to clarify something.
Sorry, just catch that paragraph.
Page 25, paragraph 1.7.9. You state, and this is in response to the point I had raised with you, that the answering affidavit in the review application was deposed to by General Pierre, who had assumed that position by then.
Correct.
You state that even after he, General Mkhwanazi, was fully aware of the contents of General Pierre's affidavits and the full proceedings, General Mkhwanazi continued to cover up the illegal instruction he had been given by Minister Mthethwa.
Correct.
Now, what form did this cover-up take? On what basis do you say he continued? Firstly, he covered up, and secondly, that he continued to cover up. Thank you.
Maintaining silence. Because what happened, Commissioners, while that period between Richard Mkhwanazi being suspended and then having a suspension uplifted and then having a suspension reinstated and the court case is going on, during that period, the whole thing was argued out in court. And when it was argued out in court, it was all over the media. And the Supreme Court of Appeal go into some detail about how General Pierre misled the High Court. And General Mkhwanazi kept quiet. He had a duty. He could not ignore that duty. And that duty was to step forward and say, well, hang on a minute. Actually, General Pierre's version of events is not true.
Was he a party to this application?
I'm saying he was. And the reason I say he was is contained within Annexure W.
And Annexure W.
Annexure W.
Page 475, that's where it starts.
Yes. If you have a look at page 14 of Annexure W, which is page, just bear with me a second. I'm going to have to count the pages. 1, 2.
If you perhaps give a sense of what you are looking for, we might try and assist.
14. Aha. Here we go. It's page 488 of the evidence bundle.
488.
488 of the evidence bundle.
Thank you.
So this is a presentation that was made on the 13th of November 2015 by the Minister of Police.
Yes.
It was, in fact, Mr. Mthethwa was the Minister of Police then. This was a presentation by the Minister of Police to Parliament. And it's been uplifted from the Parliamentary Monitoring Group thing. So this was made on the 15th of November, 13th of November.
It speaks of a grievance. It doesn't speak anything about, it's not answering
No,
my
but
question.
what it's showing, Commissioner, is that Lieutenant General Mkhwanazi lodged a grievance against the National Commissioner for lodging false affidavits in court regarding Lieutenant General Mkhwanazi's case. And the point I'm trying to make is this corroborates the fact that other than lodging a grievance, he did nothing about it. He allowed her to lie to the court.
But that grievance has a finding as well further on in the, on the same page. The first point speaks to the grievance lodged by General Mkhwanazi. Then there is a finding.
Yep.
And the finding says
The finding says the National Commissioner informed the court wrongly with regard to Lieutenant General Mkhwanazi's actions on Gluli matter. So what she actually did, what General Pieka did, was she informed the court, and that's borne out in the judgment. She wrongly informed the court that General Mkhwanazi had not received instructions from a higher authority. She said that was a misunderstanding, and I'm going to supply a confirmatory affidavit from General Mkhwanazi. It was never supplied. There was no, and even when it went to the Supreme Court of Appeal, they still couldn't supply a confirmatory affidavit. So the whole thing was hushed up. And what I'm saying, Commissioners, is if there was going to be any transparency here, it should have been a sworn affidavit by General Mkhwanazi informing the court and opening a docket against General Pieka for lying to the court, which in effect, apart from being perjury, is the offence of defeating the ends of justice. And no such event ever took place.
I think my point is he wasn't a party to these proceedings, so he didn't have standing to file any affidavit. That's my point.
He wasn't a party, but he knew what was going on.
Yeah, but he wasn't a party. My question was he a party? And you said yes, and you referred us to this document.
He was a party to the original proceedings.
Yes.
The Part A.
Where you are saying he should have filed an affidavit, I'm saying he wasn't a party to those proceedings where now General Pieka is the party that is being sued. So he wasn't a party. You understand what I'm saying?
I understand you.
Yes. I think that's the first point. The second point, in the judgment, in the Murphy judgment, and this I think we accept it was in 2012. I think it was in 2013.
Say again?
In 2013, that's the Murphy judgment, right?
Yes, yes.
And it states at I'll read it for you.
What's the page number?
Page 436. And this is about the point of you saying he didn't speak up for a whole 28 years, I think you say, and spoke up for the first time in 2020 before the so-called Zondo Commission. And I'm reading this just to say it seems to suggest differently from what you're saying. At page 436, paragraph 207, it says, in paragraph 45 of the founding affidavit, FUL alleged that the acting commissioner publicly stated in Parliament that he took the decision to withdraw the disciplinary charges on instructions from authorities beyond him. And then Full added that by acting on the instructions of authorities beyond him, the acting commissioner failed to act independently. So it seems that at least Full, FUL, was aware when they filed their papers that he has spoken publicly, that
in fact,
the decision, let me finish,
yeah, sorry.
That the decision that he took was imposed on him from higher authority. So why do you say that he kept this quiet until only in 2020?
Because at the parliamentary committee, it was asked what higher authority. He couldn't answer. He should have said the Minister of Police instructed me. Instead, he covered the thing up.
So the criticism is he didn't state it's the minister.
In fact, what happened, if you look at General Pieka's conduct in the FUL response, she said, actually, what he said at Parliament wasn't correct.
Yes.
He made a mistake. What he actually meant was the NPA had decided to withdraw the charges, and that's why he followed suit. The whole thing was a complete lie.
Okay. So that's Piecha. For now, I was just clarifying.
Yes.
I was clarifying that when the FUL prepared its answering affidavit,
Yes.
General Mkhwanazi had already said in Parliament that he made the decision on higher authority, or it was dictated by higher authority. And your criticism, and I hear you.
They couldn't get
you
it
say
out of him.
Your
Parliament
criticism is he didn't say the higher authority is the minister.
That's what he
your
should have said.
Okay, thank you. Thanks, Mr.
Thank you.
Just one issue with you, Mr. Sullivan. Going back to page 488.
Page?
488. Remember, throughout this section of your affidavit, the point you sought to make was that General Mkhwanazi has kept quiet for 8 years about the political interference that took place when he was acting national commissioner. Doesn't that paragraph in 1, the bullet point that sets out the grievance that he lodged in 2015, undermine that argument? Because it shows that as far back as 2015, he spoke about the fact that General Piecha misled the court in relation to the Mdluli matter. And then it ties up with what Commissioner Baloyi says, that even prior to that, he had said in Parliament that there was interference. Although he did not say who interfered, but at the very least, he did say there was interference.
I hear you, Commissioner.
So you cannot then, in those circumstances, say for 8 years he did not say anything, because what this presentation at least shows is that when he became aware that General Piecha may have misled the court, he lodged a grievance against her on the very Mdluli matter, so on the subject of the very issue that we are discussing. The detail may not have been there, and because you were not part of the presentation, maybe you would have expected more detail, but it's not correct to say there was complete silence for 8 years. That's the point I'm trying to make with you. That at the very least, there was something, not the detail that you expected.
There was something, Commissioner, but there wasn't transparency. What there was a complaint against Piecha for not telling the truth. But there wasn't, by the way, she wasn't truthful. What she should have said was bang, bang, bang.
Yes.
He didn't do that.
But he goes a step further
up.
and he says he was not even consulted when the affidavits were prepared. The point being that if he was consulted, he would have stated the true facts.
Well, except for the fact that when he made the first affidavit in the Part A, he kept quiet about the matter. If you look at the pleadings on the FUL matter, on the freedom under law matter, they make it crystal clear that their pleadings, their application is based on the statement he made in Parliament on the 19th of April, where he stated to Parliament, when they said to him, why have you put this man back to job? Why have you lifted the charges against him? He said, I've acted on the basis of a higher authority. And they asked who? He refused to tell them. He couldn't tell them. So I'm saying he covered it up all the way along. And what that cover up comprised of, yes, you can say that this complaint, which was a grievance, there should have been a sworn affidavit stating the chapter and verse. It only came out in 2020. And please listen to this very carefully. What he stated to the Zondo Commission in 2020 was not chapter and verse. What he should have done was given a blow by blow, where the meetings took place, when they took place, the dates and times and everything. He didn't. The thing was kept vague. And I'm saying it was deliberately kept vague.
But in the affidavit before the Zondo Commission, he does mention the days of the meetings. If you go to 376,
376.
376
Yep,
and that's the affidavit before the Zondo Commission.
correct.
You will see that he mentions the meetings, he mentions the
Are you
date of,
paragraph number, sorry?
the dates of the letters.
Yes, that's referring to dates of letters.
Yes.
But the information that's missing, Commissioner, is the dates of the meeting in respect of the police minister. That meeting date has been kept vague. There's no date there.
Yes. But we know that it is March because the letters are the March letters. So when he refers to the IG opinion that was first issued and then was later withdrawn, so he's referring to the March date, and that much is clear from paragraph 48 on page 356, that we are in the March period because we know that the meeting with President Zuma happens in June. So although it doesn't specify the date of the meeting, but it's quite clear that the date is between the
Somewhere around then.
It's between the two opinions by the Inspector General. So
Yeah.
it would have been between the 6th of March and the 19th of March. That's at least how I read paragraph 48, that the meeting would have happened between those two dates.
Commissioner Khumalo, perhaps what might assist is reference to page 363.
Yes.
At the bottom of 363 is paragraph 39. That gives a date on 23rd April 2012, Lieutenant Drummond authored a further letter. This is in the sequence, when he's narrating sequence of events.
Sorry, page?
It's paragraph 39.
Sorry, what page number?
Sorry, I was looking at the wrong version of the document, but it's paragraph 39.
372.
If you go then from 372, paragraph 39, that's where he introduces the date, the letter by Lieutenant General Dramat of 23rd April 2012. And then at 40, he quotes that letter. And then at paragraph 42 under heading H, interference by Minister of Police. It says, a few days after my conversation with Advocate Khadebe, I chaired this meeting at the police headquarters, and he continues. So if one were to follow his timelines, it would give you a good sense of when the meeting, although admittedly it's not dated, took place. Would you have a challenge, a difficulty with that?
Commissioners, the only difficulty I have with that is that if it's such an important meeting, why don't we have a date for the meeting and a time for the meeting that says, on this day at this time, the following meeting took place? I'm just saying that's the way I see it.
Okay.
It could well be that he's happy with keeping it vague. I'm not happy with keeping it vague.
That's why I was saying your issue is not so much that he did not disclose what happened. Your issue is that he did not give the full detail, including the date.
Yeah. When he disclosed it on the 2020 affidavit, in the 8 years preceding that, he had an opportunity to come out and say, by the way, on this date, at this time, I had a meeting with the Minister of Police, who unlawfully instructed me. The only time this comes out is here, 8 years later. It never came out before then. Never. Thank you.
On that score, then, may I invite us to go to your page 23 of your statement?
Page?
Page 23.
22.
23.
Uh-huh.
And paragraph 1.7.5.3, you actually make a much stronger allegation against General Mkhwanazi. You say, second, he appears to have colluded in allowing SAPS to put a dishonest version in their answering affidavit to Part B to the court.
Yep.
When then Commissioner Pierre falsely stated that there had been no instruction to General Mkhwanazi from above.
Yeah. And the reason
Now,
I'm saying that,
my question is, what must the commissioners look to see the collusion that you reference?
because at that time, we have to cast our minds back to 2012. So during that whole period, there was a lot of media coverage. Major General Richard Mkhwanazi, or Lieutenant General, Richard Mkhwanazi, was in the media every single week, 2 or 3 times a week. This whole thing, as it was being played out in court, was all over the media. Now, by his own account, he spent 2 years sitting at home twiddling his thumbs during that period, while General Mkhwanazi went out and gave a complete pack of lies to the court, which was published. It was all over the media. I'm saying, if I know about something that's wrong and I keep quiet, I'm assisting in the cover-up. And that's the point I'm trying to make. And if you go through the documentation, if you go through the judgments, and you look at the timeline, there's absolutely nothing between his first statement in May 2012 and the Murphy judgment, still nothing. He only comes out with it for the first time 8 years later. Why keep quiet? Keeping quiet for 8 years, I'm saying, is acquiescing to crime.
I think, Mr. O'Sullivan, it's one thing to say, by keeping quiet, he acquiesced in a lie that he knew about. So firstly, you have to establish he knew that General Mkhwanazi in her affidavit has said this, and he chose to keep quiet. So you have to establish that fact first. And I don't know that you have said enough in your testimony that indicates he knew, as a matter of fact, not what you say, he was at home for 2 years, it was playing out in the media, he should have been aware of it. It seems to me that you would first have to establish that he knew, as a matter of fact, indisputable fact, that this was said in the affidavit, and knowing that he made the decision to keep quiet. That's one thing. But if to say that he colluded, and perhaps in fact he does collude if he does that on those facts, if he knew and he chose to keep quiet, he colludes by omission. That's the one form in which he could have colluded. The alternative formulation is he was deliberate. He was part of the cover-up. It's not a case of omission, but it was deliberate. So in a way, it was by commission, right? He knew this is happening, and he chose to be part of that lie. I don't know that beyond your, whether you can put it as high as that, and yet your statement here, where you say appears to have colluded in allowing the subs, I'm not sure that it is backed up by anything that you have said. We've gone through a number of instances where he has said and spoken, including up to the grievance that he laid against General Mkhwanazi. And in all of that, I haven't seen, I must say, speaking for myself, that I don't see the positive and intentional act that you are seeking to convey in 1753, that he intentionally participated in a General Mkhwanazi cover-up.
Okay, I hear what you're saying, Commissioner, and I'd like to draw your attention to what I say at paragraph 1.7.6. Because I'm saying there, in contrast, General Mkhwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Mkhwanazi's affidavit. I'm saying I find that claim in that affidavit unconvincing. And the reason I find it unconvincing is because he had made a grievance against her for being untruthful in her answering affidavit to the High Court. And I go on to say, General Mkhwanazi therefore knew that the allegation of an unlawful instruction to him was at the centre of the application. And the reply from General Pieka would have to admit that central allegation if she was not going to perjure herself.
Thank you.
Sorry. Mr. O'Sullivan, you give two reasons for what you have just said now. You say, in contrast, General Mkhwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Pieka's affidavit because he was in his period of rest at home in KwaZulu-Natal at the time. I find this claim unconvincing because, and then comes the two reasons,
Yes.
or then come, not comes, the two reasons that you give.
Yes.
Even if I take a bit of time, I will read both. The first one is this. General Mkhwanazi was aware of the allegations in the FUL application because the founding affidavit in the agent application had been served on subs whilst he was acting National Commissioner, and he had deposed to the initial answer in that application, but chose to sidestep the unlawful instruction allegation and simply not comment. General Mkhwanazi, therefore, knew that the allegation of an unlawful instruction to him was at the center of the application, and the reply from General Pieka would have to admit to that central allegation if she was not going to perjure herself. Let's focus on that reason and not overlap onto the second
Yes.
reason. Yes.
Of course, you can read different things into it,
Yeah.
the way I phrased it.
On what basis would you want to suggest that General Mkhwanazi would have known what General Pieka would say or not say in her answering affidavit on the Part B of the application, going so far as to talk about perjury and so on?
My argument, Commissioner, is very simple. I go to Minister Nshleko's presentation in 2015 to the Parliamentary Portfolio Committee on Police, where he talks about the grievance. And he didn't make the grievance in 2015, he made it earlier than that. So here he was making a grievance about the alleged perjury of General Pieka. But what he wasn't doing was saying it's perjury because this is what really happened. He just said she perjured herself.
But here you are talking about what General Mkhwanazi ought to have known what General Pieka would say, not what she had in fact said, what she would say in deposing to the Part B answering affidavit.
He would have
so
He only knew about it after.
so those are two different things. What may have happened a couple of years later does not answer what General Mkhwanazi should have known with regard to what General Pieka would say in her Part B answering affidavit. That's where I am.
So, yes, Commissioner, but the point I'm making is he knew what the central allegation of the Freedom Under Law application was. He knew. The whole application was
Yes.
found on this allegation that he had received unlawful instructions.
But what's going to be deposed to is not his affidavit. And if nobody invites him to come depose to the affidavit as the person who actually knew what had happened, then on what basis can you fault him with regard to what the content of General Pieka's affidavit was going to be?
Let me give you an analogy, Commissioner.
Yes.
If you look at Section 34 of PRECA, the Prevention and Combating of Corrupt Activities Act, it makes it an offence for a person not to report a particular category of crime. We're talking here about the previous acting commissioner of police, who is now sitting at home twiddling his thumbs, watching all the media coverage. I cannot believe he wasn't able to see what was going on in the media. And instead of stepping up and saying, well, hang on a minute, this is not true, he kept quiet. And the point I'm making is he had ample opportunity to not keep quiet, and he didn't do so. And he was a policeman.
I know right at the beginning of this engagement, I said that we should not conflate the two reasons that you give, and I'm going to preach exactly what I had said to you. You see, the difficulty I have with what you have just said about not believing that he would not have become aware of what the media was saying. In your second reason, you actually accept the possibility that he might not have become aware of what was out there in the media. You go so far as to say that, but if he had himself not become aware, people close to him would surely have told him. So in answering my question with regard to the first reason, I do not think you can peg your answer on him having heard or seen or read what was out there in the media.
Well, of course.
Because then you are contradicting yourself.
No, of course. If the commission gives him the benefit of the doubt.
You first gave him the benefit of the doubt.
I don't necessarily, I'm saying I wasn't convinced by his argument.
Yes.
Okay? And the reason I wasn't convinced of his 2020 affidavit was because in 2015, he was moaning and grievance about Commissioner Pieka lying under oath against him, about him, that he didn't say this, and therefore, he was never offered a confirmatory statement. At the end of the day, Commissioner, what it boils down to, from me as an evidence giver, is it's I suppose, 80% gut feeling. But if you look at the reality of it, there's no evidence between 2012, when he had an opportunity to come clean, when he made the first answering affidavit to the Part A, he had an opportunity to come clean and tell the truth. He kept quiet. And the first time we hear about it was at the State Capture Commission, and that comes out in his affidavit. And it really then is utilized at this commission. But what he doesn't do at this commission is said, by the way, I kept quiet about it for 8 years. I told the State Capture Commission, I just think it should have been a lot more transparent. If we are talking about a junior policeman, I can understand, but we are talking about a person who was the acting commissioner of police. He was in charge of running the police service, and he was the man, nobody else, him. He was the one that unlawfully put Richard Ndluli back to work, forcing civil society to bring urgent applications to get Richard Ndluli back out from his office. And I'm going to paint in my closing argument, or whatever you want to call it, the reality between that and what went on at the 6th of July media conference, because there are similarities here.
Yeah, those are related issues I will immediately accept. But you are dealing with something specific here, which is about why, and you keep repeating the words, he was sitting at home twiddling his fingers. I will not go so far as to say he was twiddling his fingers, but you repeatedly refer to the fact that he was sitting at home. And your point is more that he had all the time to basically anticipate whatever it is General Pieka would say about this, lest she perjure herself. That's the substance of the question. I accept the other issues that you've just referred to in response to my question are related, but they are not really what you are addressing in 1.7.6.2. So that is, my point is, this is somebody who is sitting at home under the circumstances that we all know, based on the testimony or the material before us. Now, on what basis must he insert himself and say, I'm lifting my hand, here I am, just in case the current incumbent General Piecha might perjure herself. I'm offering myself. Why should he have done that? Shouldn't those who were preparing the answer, the Part B answering affidavit, have been the ones who approach him specifically and say, you are the person best placed to answer this, therefore, please tell us what you know so that we file your affidavit as a confirmatory affidavit to what General Piecha is going to be saying?
Well, it's a tricky one, Commissioner. The reality of the situation is that during that period of time, President Zuma was running the country, or running the government, and we had all these things going on. And I cannot say beyond reasonable doubt that he colluded. But what I can say is he would have known that in order for her answering affidavit to be truthful, she would have had to say that which he refused to say, which is that he got an instruction, according to his version of events later, from the commissioner, from the Minister of Police to reappoint General Mkhwanazi. And let's give him the benefit of the doubt and say he wasn't listening to what's going on in the media. Let's just say that he was blind to all these things that were going on. But somehow he was able to make a complaint, a grievance. If I was in his shoes, I would have been beating a path to the door to say, hang on a minute, let's tell the truth here. But he couldn't. And the reason he couldn't was because it was still too short a period after the event where he had acted unlawfully by carrying out the instructions of the Minister of Police. But 8 years later, you know, time has passed and water has gone under the bridge. Now we can put it out there. I believe he should have put it out there a lot sooner.
Let's move on